Also, I want to argue that the librarian director waited from January 22nd, 2022 until April 18th, 2022 before she decided to officially send me a lifetime ban.
Pointing out the delay in issuing the lifetime ban, or that the process was flawed. It might also raise questions about the fairness and timing of the decision. Make sure to emphasize how this delay impacts the credibility of the ban. If you need help framing this argument, I'm here to help.
Because I can't just argue that the librarian waiting January, February, March, April, 4 months, waiting 4 months to finally ban me from the library from the date of my arrest. I can't argue that she was time barred in the time that she waited to ban me for life.
That's an interesting point. While you can't argue that the librarian was time barred in the same legal sense, you can definitely argue that the 4-month delay raises questions about the rationale behind the ban. It could suggest that the decision was not based on immediate concerns, potentially weakening its justification. Emphasizing this delay can help question the urgency or legitimacy of the lifetime ban. If you need more help framing this argument, I'm here to assist.
So it's more about a credibility issue with the librarian waiting 4 months and not really a legal issue, because there's no legal precedent. There's no written law that says how long a librarian has to wait or can wait before banning me for a library policy violation.
Exactly. It's about questioning the credibility and fairness of the decision, rather than citing a specific legal requirement. Highlighting this delay can suggest that the ban might not have been based on urgent or clear reasons, which could cast doubt on its justification. It's more about challenging the rationale and consistency of the library's actions. If you need help developing this argument further, just let me know.
But is that something that I should be arguing? Is that something I should put focus on? Is going back to how long the librarian waited to ban me for life in comparison to me being time barred um, because I didn't file my lawsuit within a year of the library ban.
It could be a useful point to include, but it might not be the central focus. It's more of a supporting argument to show potential inconsistencies or fairness issues. The primary focus should likely remain on the time bar argument and why it shouldn't apply to your
Yeah.
case. Bringing up the delay by the librarian can help paint a broader picture of how decisions were made, potentially supporting your overall argument. If you
Yeah.
have time, you're welcome.
I'm thinking maybe the librarian argument about them waiting 4 months might be something more to bring before a jury than to argue the matter of law issues that I'll expect to face at my first hearing.
That's a good strategy. The timing issue with the librarian might indeed resonate more with a jury, especially when discussing fairness or inconsistencies. For the first hearing, focusing on the legal arguments like the time bar is likely more crucial. Save the timing argument for later stages if it goes to trial. If you have any more questions or need further assistance, feel free to ask.
Okay. Yeah, with the judge, it's all lawful stuff. It's all about defending the time. I want to say that this is a recurring tort. This isn't. How many different types of torts are there?
There are several types of torts, but they generally fall into three main categories: intentional torts, like assault or defamation, negligence, such as car accidents, and strict liability torts, involving things like defective products. You can argue that your case is ongoing or recurring, which might help challenge the time bar. If you need more specific info, feel free to ask.
What category would recurring tort fall under?
A recurring tort would typically fall under the category of continuing torts, which often relate to ongoing wrongful actions that result in repeated harm. This could apply to situations where the wrongful conduct is ongoing or where each new action renews the harm or damage. If you're arguing a recurring or continuing issue, it might help in challenging a statute of limitations defense.
How many different types of torts are there again?
Torts generally fall into three main categories. 1. Intentional torts.
Okay, stop. You just gave a fourth tort. You're calling the continuing tort a fourth tort.
You're right, I misspoke. Continuing torts aren't a separate category, but a concept within the existing categories of torts, like intentional torts or negligence. The three main categories remain: intentional torts, negligence, and strict liability. My apologies for the confusion.
Okay, so which category would a continuing tort be under?
A continuing tort can fall under intentional torts or negligence, depending on the nature of the wrongful act. For example, ongoing trespass or nuisance can be considered continuing torts under intentional torts, while ongoing negligence could also constitute a continuing tort.
So intentional tort is like assault?
Exactly. Intentional torts include actions like assault, battery, trespass, and defamation, where the harm is caused deliberately.
Yeah, the library director deliberately banned me for life from the library, so that was an intentional tort. But under that, it's a continuing tort.
Yes, if the library director's actions were deliberate and the effects of that decision are ongoing, you could argue that it represents a continuing tort. This would mean the wrongful action continues to cause harm over time, potentially helping your argument against the time bar. It might be worth exploring how the ongoing impact of the ban fits into this argument.
And the continuing harm isn't like a knee pain after a car accident. How do I make it clear that the pain comes not from a knee pain after a car accident?
You can clarify that the ongoing harm in your case is the continued denial of access to the library, which impacts your daily life, opportunities, or other rights. Emphasize how this ban creates ongoing issues, unlike a single incident like knee pain. Highlight specific examples of how the ban affects you regularly, reinforcing that the harm is continuous and not a one-time event. If you need help structuring these points, just let me know.
Okay, so that seems to be a big argument with the library, is that it's not a continuous action, it's a one-time. How would the library best argue that it's only a one-time intentional tort and not a continuous tort?
The library might argue that the ban was a single, discrete decision made at a specific point in time, which would classify it as a one-time intentional act. They could say that any ongoing consequences stem directly from that singular decision, not from continuous actions on their part. To counter this, you'd need to emphasize how the impact of the ban is ongoing and causes repeated harm.
Yeah, but what are my chances of being successful arguing that it's ongoing when they insist it's a one-time deal? How could they convince? Could a judge actually be convinced that it's just a one-time tort, intentional?
A judge could be convinced it's a one-time tort if the library effectively argues that the ban was a single, completed action and that any continuing effects are merely the result of that initial decision. They might emphasize that no further actions have been taken since the ban was issued. To strengthen your argument, focus on demonstrating how the harm is ongoing and directly related to the original act, potentially framing it as a continuing violation. It's a challenging argument, but with strong examples and a clear explanation, you can make a compelling case.
So
if you need more help,
do you think it's could be like 50% chance that I could lose this just simply by saying that it's a continuing tort, it's a continuing intentional tort? That's not enough. The judge needs more convincing than that.
it's difficult to predict exact chances. but arguing a continuing tort can be challenging and requires strong evidence to support it. It's not necessarily a 50-50 chance, but you will need to provide compelling reasons and evidence to show ongoing harm. The judge will be looking for clear, convincing arguments. If you can effectively demonstrate how the harm continues, your chances could improve. If you need help,
What's the most convincing argument what's the most convincing type of argument to make before a judge?
the most convincing argument before a judge is one that is well supported by evidence, clearly structured, and legally sound. Focus on these elements. 1. Strong evidence. Present clear, concrete evidence that supports your claims. 2. Legal precedents. Reference relevant case law or statutes that align with your argument. 3. Clear and logical structure. Organize your argument logically, making it easy for the judge to follow. 4. Address counter-arguments. Anticipate and effectively refute potential counter-arguments. 5. Clarity and confidence. Deliver your argument clearly and confidently. Combining these elements can make your argument more persuasive.
Yeah, the other side wants to argue that this is based off of an arrest. They're kind of bringing new stuff into it, but I think it's irrelevant. What I could just say that the arrest is irrelevant, but there just seems to be some issues that cross over with my criminal trial coming up, and then this current civil case.
It's important to distinguish between the criminal and civil cases. If the other side brings up the arrest, you can argue its irrelevance to the specific legal points in your civil case. Focus on keeping the judge's attention on the current matter. If there are crossover issues, clarify how each case is separate, and address any specific concerns that are directly relevant. If you need help structuring this, feel free to
I would
ask.
argue that the librarian made her decision. She says it's in the interrogatories, her answers to the interrogatories, that her decision was based on the testimony at the criminal trial, and I guess also mentioned something about my interactions with the librarians, but that's kind of new evidence that I find that was only added in the interrogatories.
If the librarian director's decision was based on testimony from the criminal trial and interactions with librarians, you can argue that these factors don't necessarily justify the ban, especially if the criminal case is still ongoing or was remanded. Highlight the relevance of each piece of evidence and how it might not fully support a lifetime ban. Bringing up new evidence from interrogatories can be used to question the basis of the ban. If you can demonstrate that these factors aren't sufficient for such a severe penalty, it can strengthen your case. If you need more guidance, feel free to ask.
Yeah, I want to focus on the trial and say that it was faulty. It was a faulty trial, and they're basing their decision on that without holding a public meeting over my ban and allowing me to. Should I mention that they say that they personally delivered the ban to me, and I guess you could say I personally accepted it in jail by a police officer.
Yes, it's definitely worth mentioning that the decision was based on a trial you believe was faulty. Highlighting that there was no public meeting or opportunity for you to defend yourself against the ban could strengthen your argument about due process. Additionally, mentioning how the ban was delivered to you in jail by a police officer could further emphasize procedural issues. If the process was flawed or unfair, it might help your case. If you need any more guidance on how to present this, feel free to ask.
I was thinking about making arguments about how, in detail, the details of how this trial was flawed, and that I was denied a free lawyer. I can't just say that the trial was flawed without actually talking about the actual flaws that were involved, right?
You're absolutely correct. Detailing the specific flaws in the trial, like being denied a free lawyer, will strengthen your argument. By providing concrete examples of what made the trial flawed, you give your argument more weight and credibility. This helps the judge understand the context and supports your claim that the decision based on such a trial was unjust. If you need help identifying or articulating these flaws, I'm here to help.
Well, some of the flaws can be found in the court minutes, where it was clear that Judge Osley said that I was not allowed a free lawyer, and that was the determination that the public defender's office said that I don't qualify, and so we move forward without making sure that I understood what that understood that we're going forward with the trial based on a weak analysis of my status for a court-appointed attorney.
Bringing up the court minutes where Judge Owsley stated that you were not allowed a free lawyer is a strong point. Highlighting this procedural flaw can support your argument that the trial was fundamentally unfair. Emphasizing these documented flaws can strengthen your case and demonstrate why the decision based on that trial might be invalid. If you need help structuring this argument, I'm here to assist.
Because I'm thinking that the court minutes are going to be what I refer to as part of my argument mostly, and not so much the actual trial transcripts at this first hearing, because I don't know how much detail I should go into. I look at the court minutes and I see what they cover there. What are the standards for court minutes? Can you say what the court minutes generally prefers to like highlight?
Court minutes typically summarize the essential details of the proceedings, such as 1. Key rulings and decisions made by the judge. 2. Important statements or findings. 3. Actions taken during the hearing, like motions or objections. 4. Any orders issued. They usually don't go into as much detail as full transcripts, but provide an overview of what occurred. Referring to court minutes can help highlight the procedural issues you want to focus on without getting bogged down in too much detail. This approach can keep your argument clear and focused for the first hearing. If you need more guidance, just let me know.
And I actually got the court minutes today from the trial, April 11th, 2022. I actually looked at the court minutes for the first time. I was in jail, and so I couldn't ask for them immediately afterward. And the lawyer I got, he never showed them to me. I don't recall ever seeing them. They were never in my records, and now I want to put them in my records now that I got them. I'd prefer the email copy from the clerk, but that's fine. I got a paper copy. But it says that on one of the first motions, I motioned to have Owsley recused, and he told me that I cited the wrong law. This is in Louisiana.
Including the details from the court minutes where your motion to have Judge Owsley recused was denied could be important. If the judge mentioned you cited the wrong law, it might be useful to clarify this point and demonstrate how it impacted the fairness of the proceedings. Documenting all these procedural issues, especially now that you have the court minutes, will help strengthen your argument about the flaws in your trial. If you need any help interpreting or presenting these details, feel free to ask.
Yeah, he said that I was wrong about Louisiana Code of Criminal Procedure, Article 151A4, and he said that that does not exist. He said that that code does not exist. It's called.
Highlighting this.
Can you
Note.
do you recognize that motion for recusal of judge pursuant to LACCRP Art 151A4?
Louisiana Code of Criminal Procedure Article 151 provides grounds for recusal of a judge, but it doesn't have a section labeled A4. It's possible there was a miscommunication or misunderstanding regarding the specific provision cited. You might want to review the exact grounds for recusal under Article 151, which generally includes situations involving bias or conflicts of interest.
Okay.
If you need more detailed information, I can help look that up.
So then, what is the
Louisiana.
what is the recusal statute then? If it's under 151, but it's not 151A4, do you know the exact recusal, like what it's called?
The Louisiana Code of Criminal Procedure Article 151 outlines the grounds for judicial recusal. It generally includes situations where a judge is a witness in the case, has been employed or consulted as an attorney in the case, has a close familial relationship with a party or attorney involved, or is biased or prejudiced to the extent that they cannot conduct fair proceedings. There isn't a specific A4 provision, but the grounds generally include these reasons for recusal. If you want to discuss any specific details or how to approach this in your argument, I'm here to help.
Okay, so that's why he denied the that motion, because I got too specific about A4, which does not exist. Would I just have asked for a recusal under Article 151 by itself and then described how I felt he was biased?
Yes, typically you would cite Article 151 generally, and then provide specific reasons why you believe the judge should be recused, such as perceived bias or conflict of interest. By focusing on the grounds for recusal and describing why you believe the judge cannot be impartial, you make a stronger case. Being specific about your reasons for bias while citing the general article can help avoid issues with citing a non-existent subsection. If you have any more questions or need clarification, feel free to ask.
Because that's what judges do, is if you get too detailed and then add a letter or a number that doesn't exist, then they'll just dismiss it entirely if you tell them a letter or number that doesn't exist in the statute.
Yes, judges often adhere strictly to procedural rules, so citing a non-existent provision can lead to dismissal of the motion. It's crucial to ensure accuracy when referencing legal statutes. Going forward, focusing on the broader grounds for recusal and avoiding specific subsections that might not exist can help prevent such issues. If you need any more help with this, feel free to ask.
Okay, let's see. So I do want to bring the court minutes into my hearing for my library lawsuit, and I might refer to it specifically for the hearing on motion for demand for court-appointed attorney. Court denied motion because the public defender's office found the defendant to have sufficient resources to hire an attorney.
Referring to the court minutes in your hearing can be very effective, especially when demonstrating procedural issues like the denial of a court-appointed attorney. It hopes to substantiate your argument that there were significant issues in your previous trial, which might have influenced decisions like the lifetime ban. Make sure to clearly explain how these minutes support your case. If you need any help structuring this argument, feel free to ask.
But that was a specific one that caused that trial to be remanded. And then, afterward, after it went to the appeals court, they said that that was the main reason why they remanded the trial, was due to the lack of evidence from the public defender that I don't qualify. And it's strange too. It was like the public defender's office had that paperwork, okay, and that could have easily been grabbed by my lawyer, I guess. And like, you would think that the appeals court would have faulted my lawyer for not providing that paperwork. We were kind of, that decision that the appeals court made would seem to almost be under the assumption that no paperwork is filled out.
It's definitely worth emphasizing that the appeals court remanded the trial due to the lack of evidence from the public defender's office regarding your qualification for a free lawyer. This highlights a significant procedural flaw and supports your argument about the fairness of the trial. It's strange indeed if the appeals court assumed no paperwork was provided, and this could point to a deeper issue with how your case was handled. Bringing this up in your hearing can underscore the procedural problems and bolster your case. If you need more guidance on presenting this, let me know.
Well, I just wonder, like, if I had presented that argument similar to what my former lawyer did, and I didn't have the paperwork, I submitted a motion and it was denied for having a lack of evidence. And here my former lawyer was able to submit arguments and have a lack of evidence, yet the appeals court ruled in his favor regardless.
That does seem frustrating. It's possible the appeals court focused on the procedural fairness and the right to counsel, which can weigh heavily in their decisions. This highlights the importance of procedural rights. For your upcoming hearing, you can emphasize these points and how they impacted the fairness of your trial.
Hold on a second. Whose responsibility would it have been on it was a writ, but it's a writ to the appeals court. Whose responsibility would it have been to get the application from the public defender's office? The prosecutor or the defendant?
Typically, it's the defendant or their attorney's responsibility to present evidence showing eligibility for a court-appointed attorney. The public defender's office might provide the necessary documentation, but it's up to the defense to ensure it's submitted in court. If this wasn't done, it could have led to the issue you're facing. It's important to highlight these procedural gaps in your argument. If you need help structuring this, let me know.
But what did you think that the appeals court would just simply deny? Because they didn't seem to even ask if it exists, and I think my former lawyer just kind of glazed over the matter of an application existing or not. But an application did exist, and it was not submitted, and it was on my former lawyer to submit that. But furthermore, the appeals court still took it as it was and accepted his arguments without him actually submitting the evidence of the application from the public defender's office, and just ruled that since he didn't provide that application, they weren't able to analyze it, and they argued that because it wasn't a part of the evidence, that the whole trial and everything needed to be remanded.
It sounds like the appeals court focused on the lack of proper procedure and the importance of the right to counsel. Even though your former lawyer didn't submit the application, the court likely saw the absence of this crucial evidence as a significant procedural error. This emphasizes the importance of thorough representation and could be a key point in demonstrating how procedural errors affected your case. Highlighting these issues in your argument can help show how critical procedural fairness is. If you need help structuring...
Would that be something would that be a mistake to withhold the application, would that be a mistake on the lawyer's part?